My pleasure today to introduce our first Lunch and Learn speaker. This again is for the Chemergy 2.0 EPSCoR program we have. We've invited also people outside of the EPSCoR program. So if you're here today, welcome. Hope you're able to learn something. Just as context, our EPSCoR program is an NSF-funded project to build capacity specifically in the area of biomanufacturing here in the state of Iowa. So today we are very grateful for Greg Forney's time. He is one of the technology transfer officers within OIPTT at Iowa State University. I've been able to chat with him a little bit about what he's going to describe, and it should be not just Iowa State centric, but applied to what many folks encounter when they discover something new in their academic research. So he will present a little bit, but there should be plenty of time for questions. And as you saw when you entered the room, we are recording this, so we can share it to those who weren't able to make it today. So I don't want to take any more of Craig's time. So I will just monitor the room, letting people in here. And then when we come to the question and answer, I can help as well. So Craig, why don't you take it away?
Sounds great. Good afternoon, everyone. Let me share my screen here and get the presentation up. And I think if I do this, it goes to full screen. And there we go.
Yeah, it looks great.
But based on my interactions or discussion with Nigel, I came up with the title. So you invented something. What's next? And really, hopefully, this will be useful for everyone, whether you're at Iowa State or not. I tried to make it not Iowa State centric, and so there's just a little bit of information there. But there's certainly a recognition that policies and procedures vary from institution to institution, and so. But I think what I'll have to say is pretty much what's going to happen across institutions. As Nigel mentioned, I'm the Assistant Director for Licensing and Business Development in the Office of Innovation and Commercialization. By training, I have my PhD in chemical engineering from a very long time ago. I spent a couple decades in the private sector, mostly doing business development work, and then came back to Iowa State in 2012 to join the office I'm in now. I was a commercialization manager for a long time, which meant that I was much more active with faculty evaluating and trying to commercialize inventions. And then I've been managing the group for the last couple of years. So a little bit of a background on me. So you have invented something. You don't maybe know what to do. What's the first thing you want to do? In my view, the first thing you should do is disclose to your tech transfer office. And there's a number of reasons for this, right? One of it is that it really helps to fulfill your institution's obligations to the federal government under the Bayh-Dole Act. When you receive a grant from the federal government, you sign it, or your institution sign it, there are some obligations associated with that. One of which is to notify them of subject inventions that result from performing that federally funded research. And so this, I referred to the Bayh-Dole Act that it codified certain rights that are given to those institutions, including ownership to subject inventions for the purposes of, protection and commercialization. But the other thing that it does is it provides a mechanism for notification to the federal government of those subject inventions. Now, this doesn't replace any reporting requirements that you might have elsewhere. Elsewise, I mean, that's still the case that you have to do those things. But this is a kind of a unified method, by which those subject inventions are reported to the federal government. And one of the things that the Bayh-Dole Act does provide is for the government to use those or to practice those inventions for its own use. And so this again kind of provides that mechanism for the government to understand what those inventions are and to convey those rights. I put at the very bottom of this slide, just a text out of the Bayh-Dole Act, and what was the reason that this was enacted, and it was to provide for Congress to use the patent system to promote the utilization of inventions arising from federally supported research or development. So prior to the Bayh-Dole Act, any federally funded inventions were assigned to the federal government. And it was responsible for any commercialization activities. And the general consensus and the reason that the act was passed was that the federal government did a horrible job at that. And by and large, inventions from those federally supported projects weren't utilized. And I won't go through any of the numbers, but if you were to look into this, you'd see that the utilization of inventions post 1980 resulting from this is astronomical compared to what happened before. So that's the first aspect of what we're doing, is disclosing to your tech transfer office. And the other thing that happens is this begins the process by which the TTO can start to evaluate these subject inventions for further investment. And by investment, I'm really talking about protection of that intellectual property, and not necessarily inventions in tech maturation. So, I'll take another step back. In general, innovations created by an institution's employees, whether those are faculty or scientists, postdocs, graduate students, et cetera, are owned by the institution. And in the case of ISU, those innovations are then assigned to ISERF, the ISU Research Foundation, for protection and partnering. So your institution has, by nature of your employment agreement, has ownership of any innovations that you create, in the practice of doing your job. And so that's the basis of that. From a practical standpoint, when should you disclose? And what I like to tell people is, it's really when proof of principle has been demonstrated, it not at the conception stage, but really when you've done some work in the lab that has shown that it has, that the principle is there. And, at ISU, we like to see that kind of when you're preparing your first draft manuscript. Part of that is because it's a written enablement of what's going on. It allows us to understand what you're trying to get at. But it also is one of those things that we can use to base any patent applications we have or are going to file on. We'll need to have some sort of manuscript to begin with. So when you're at that stage, that's a great time to disclose. Which is not to say that you can't contact your TTO earlier than that. You certainly can. I mean, a lot of times we'll have conversations about what the innovations are shaping up to be. And we'll often have maybe suggestions on things that you might want to more fully flesh out that might make it more commercially relevant or commercially interesting. But certainly at that point that you've got your first manuscript in preparation, that's a great time to reach out to your tech transfer office and potentially disclose. And so, maybe the first question you might ask is, what will the tech transfer office do with that disclosure? And again, from an ISU perspective, we typically review the technology from two different aspects. And the first is, what's the commercial opportunity? And, we want to understand what the type of technology is. Is it a replacement technology? In which case, we're going to look at what are those advantages that it brings to the table compared to existing solutions, as well as what liabilities there are. We'll want to understand whether this is just a drop-in replacement or more of a forklift. Which will imply what kind of investment a licensee will need to make in order to enable or to utilize the invention. We'll want to understand whether this is something that might enable or be applicable to U.S. manufacturing, or is it really only something that's going to make an impact in maybe a foreign supply chain? The U.S. government has a vested interest, as do I think as do many of us, to enhance and enable U.S. manufacturing, and we'll want to understand how does this innovation interact with that, and is there an ability to detect unauthorized usage or enforce IP rights? Often new methods are wonderful, but it's sometimes really hard to understand if someone's utilizing those without authorization or without taking a license. So those sorts of things we'll want to look at. Or is it an entirely new field of use? Is it a new material, a new process that enables something entirely new? And if it's that, we'll want to try to understand what the commercial opportunities are associated with that, and what are the scale of those opportunities to know, is this something that has large revenue potential, large manufacturing potential, and what that really looks like. The second thing we'll probably look at is it protectable at all? And what kind of innovation is it? So is it a creative work? And in the university research context, that's typically, software or applications, or maybe data sets, or is it more of a composition like an alloy or a new polymer or a new molecule that might have been first put together? Or is it a new process or device? Because that kind of directs the types of protection that we might have available to it. We're also going to want to know, what are the barriers to protection? Has there been a public disclosure that might create a bar date that prohibits us from pursuing certain things? And the types of public disclosures might be either a publication, whether that's written or oral, journal articles, poster presentations, invited talks, or even things on the internet. You might have a page for your lab's work and have innovations or references to work that's being done just on a web page, or whether there's been a public demonstration or offer for sale. Those last two are not very common, in the university environment, but they can be. Other things that might be barriers to protection or utilization might be reliance on third-party rights. So, for example, in the field of biotechnology, a lot of people use CRISPR-Cas9 technology to create or to modify organisms, which is often freely done in university environments, but has implications when it comes to commercialization, because the owners of that technology freely allow universities to use it, but when it comes to commercialization, they require different licensing rights. And other things that might be our co-ownership with a third party. When we welcome collaboration, particularly between universities or other research institutions, and we often have no problem developing an agreement on how we're going to approach the intellectual property developed there. But sometimes we might have co-ownership with a practicing entity, a company that might be involved with us, and so those things have impact on how we might approach protecting an innovation or commercialization. So we're going to want to understand all of those things. Kind of in the Chemergy context, we know this is federally funded, but if it was something else, we would also want to understand what rights or obligations we might have to a third party. So if there was a cost share that was provided by a third party that in that agreement might have given them some rights, again, we'd want to understand what those things are, and those would have an influence on our investment decisions. But I kind of prep this that we might need to talk about intellectual property, and really there's kind of 5 basic types of protectable intellectual property. Those are trademarks and trade dress, trade secrets, know-how, copyrightable subject matter, and then patentable subject matter. And then kind of related, there's some commercializable tangible property, and those are things that are tangible rather than solely intellectual, such as germplasm, which we typically view as crop varieties, antibodies, cell lines, animal models. All of those things are commercializable, but may not be protectable in the same way that we would do, again, compositions or methods or apparatuses or apparati. So really briefly to talk about these different types of IP, trademark and trade dress are things that identify products or services as belonging to a particular source. So, Coca-Cola is obviously a brand name, but it's also trademarked. When you see, that script Coca-Cola, you should understand that product originates with the Coca-Cola company. And so it's distinctive in that sense and recognizable. And if you bought a product that had that, that trademark on it, and it came from a different source, that's something that as a consumer, you might be very much disappointed in. And so it's really there to provide that to protect consumers. Trade dress is really similar. Instead of being, a script or a logo or a name or something along those lines, it's an appearance that functions somewhat similarly. And the Coca-Cola bottle there is another great example. It's got a kind of a distinctive curve to the shape of it that you don't see on Pepsi bottles or RC bottles or any other soda bottle. And so that, again, kind of gives you the clue from just a glance of whose product you're buying when you're doing that. And so these are used by those trademark holders to protect branding. And because of that, this is something that universities just typically don't do. The only trademarks they typically hold are their own names, like Iowa State University, and the logos associated with the sports teams or the like. And, they're quite zealous in protecting their trademarks, and rightly so. But, other than those types of things, trademarks are actually not used by universities very much, particularly in, when it comes to the research enterprise. There are trade secrets and know-how, and I kind of view these as related, but there's a really important distinction between a trade secret and know-how. Trade secrets can be any confidential business information, but they are enforceable provided they are kept secret and protected as such. And there are various federal and in many cases state laws that talk about trade secret and misappropriation of those trade secrets. And under those laws, it can result in prison time and substantial fines. One of the things that I kind of glanced over there is that that there has to be a protection mechanism for those trade secrets, and that's why most universities refuse to accept trade secrets as information coming in from a company, because we simply don't have a mechanism to protect them the way a company needs to. And so we're often not interested in obtaining those trade secrets because we don't have the ability to protect them in the way that a company can. Now, I kind of talked about know-how as being somewhat equivalent. I view that as the academic equivalent of a trade secret. And these are really kind of things that are like unpublished techniques or materials that confer an advantage to a lab or make a process possible, but otherwise might not be, you know, particularly noteworthy. And so that might be things like, you know, the order in which you add uh, ingredients to or reactants to a reaction, um, the rate at which or the speed at which things are mixed or how things are done, which can have a huge impact on the results of a reaction, for example, but you know maybe otherwise aren't noteworthy, right? And just simply aren't published in the detail that might be needed to repeat that in another setting. These know-how is often transferred to a licensee in conjunction with a patent license, um, but doesn't have to be. And then just as a practical note, institutional policies vary on ownership of know-how. Iowa State University does not claim ownership of know-how, but other institutions that you know I work with, other universities do. And so you may want to understand what your institution's policies are on know-how, and that has impacts on how that might be transferred outside of the lab to a commercial entity. I think the third thing on my list of protectable IP was copyrightable subject matter, and this protects original creative works of authorship, but in a fixed tangible format. So when we think broadly within society, those might be images or videos or music or literary works. We all kind of understand that you know we can't utilize Disney's Moana for our own purposes without having appropriate permission from the Disney Corporation. Same thing with music. You know, we can't just legally take it for our own without having you know some sort of consideration go to the artist and then the label. So we inherently kind of understand that, you know, from a university or a research basis, the comparable things might be software and data. And it's important to understand kind of the limitations of copyright in that it protects doesn't protect concepts, but rather the specific expression of that concept. It's you know maybe easiest to think of in terms of images. I might go to Central Campus here at Iowa State and take a picture of the Campanile, as have tens of thousands of people before me. And so, you know, I can't prevent other people from taking a similar picture, utilizing it in any way that they want, but I can prevent them from using my picture. And so that's where this idea of that specific expression is protectable. Similarly with software, you know, I may create a software program that does a particular function, and I can't prevent someone from doing a similar program or developing a program that answers or performs that similar function, but I can protect them from doing mine or using mine. You know, protection can be pretty much automatic. It's simply a matter of typing in a, you know, from a software perspective and a non-executable portion of the code saying copyright 2024 Iowa State University, right? And that's automatic. That, you know, conveys some level of protection. But there are things that you can do to enhance that by registering that with the USPTO, and there's some enhancements there, but it's not necessary. But what our office does mostly is look at patents, and I think when most people think about intellectual property, they're really considering patents. And you know these are go back to the founding documents of our country. The U.S. Constitution provides a basis for granting patent and copyright protection. And what it provides is in exchange for disclosing an invention to the public, the inventors are given a monopoly right for a limited amount of time. Excuse me. And there are really three basic types of patents that that we might interact with. There are plant patents, and those protect new and distinct asexually propagated plants. There are design patents, and really fundamentally these are protecting the ornamental appearance of an object, not really any of the functionality. And then utility patents, and kind of the fourfold test for utility patents are that they have to be novel, they have to have some utility, they have to do something. They must be not obvious to one skilled in the art, and really what we're using as that test is people just as smart as you are, right? You're skilled in the art. To someone else that's equally skilled, is this obvious that this would be the case? And the disclosure in the patent must be enabling. That is, someone without undue experimentation should be able to recreate what you're doing based on the written description that you have there. And I'm going to take one step back. But I kind of just pushed aside design patents. Design patents are very important. They're extremely useful in a commercial environment, and there's been really large litigation in the past to enforce design patents, but it's something that generally universities don't do because our technologies are extremely early stage. They're not in kind of a final form that would enter into a commercial product, and so design is really yet to be determined. And so primarily what we focus on are utility patents. Now, there's a number of different types of filings with relation to U.S. patent law. First thing to note is that the basis for filing is on a first to file basis. At one point in time, U.S. patent law was based on the first to invent. In 2012 or 13, I don't remember the exact date, the U.S. became harmonized with the rest of the world, so now it's on a first to file basis. So there is kind of more of an incentive to file early and to have that done, because anyone else independently inventing and then filing, even if they've invented after you, can establish their patent position. One thing to note is that U.S. law does allow for filing for patent protection within a year of public disclosure. So earlier on, I said that ideally for us, we'd love to see disclosure when you're first preparing a manuscript for publication. If that doesn't happen, if you've already published, but it's still within a year of that publication, we can still file for patent protection in the United States. A couple things to note on this. Right now, it's really common for publications to be available before kind of the official publication date. So you'll see often a kind of a pre-press version on the web. And that's going to be, the date at which the public disclosure happens. Often the official publication date will be later, the kind of when the publication is of record, but it may be available earlier. And so those are the things that we would, need to understand, is when was it first available to the public. And while this may sound like a really strange statement, but publication of inclusion of kind of proprietary information in a federal grant application will be considered a public disclosure when the proposal is funded. At that point in time, those grant applications are subject to FOIA requests. And so that has been, from a case law perspective, deemed to be a public disclosure upon the date of award. Now, there are opportunities when you file for federal grants to denote that you have proprietary information on that, and to denote where that is. And typically on the grant application, they will note how that you do that, and that allows the granting agency to appropriately redact that proprietary information. So it doesn't have to be a public disclosure. And I'm happy to chat with people offline about that. But generally, there's a way of making that known to the federal agency that you have proprietary information or confidential information that you don't want to be released to the public. So enough on that topic. But there are different types of applications. So if you talk to your tech transfer office, they might talk about provisional applications, utility applications. If you're in that process, there might be divisionals or continuations, and we'll kind of talk a little bit about these a little bit more. But basically, a provisional application establishes a priority date, that first date of filing, but it's not examined. They will never issue as a granted patent. They're not going to be something you could put on a plaque and put on your wall and license to a third party. It's very important from a priority date, but we're often filing provisionals to allow to establish that date, but then still allow additional reduction to practice to occur, or maturation of the technology, or generating more data to support a utility application. We can, if all the work is done, we can file the utility application first, so it can be done, but more often we're converting from a provisional filing. One of the structural differences between a provisional application and a utility is that a provisional doesn't necessarily have to have claims in it, and we'll talk about kind of the aspects of an application in another slide or two, but utility applications must, and these utility applications will be examined. An important thing to talk about, and we're going to expand upon it in a little bit, is that patents are territorial in nature. U.S. patents are generally only enforceable in the United States, but nowhere else. And so we have to understand what kind of the limitations of these patents are. The elements of a utility patent really are kind of a detailed description and innovation. If you haven't picked up a patent before and looked to read it, generally there's an abstract and kind of a general background of the invention or the application space. But then you're going to end up in a detailed description of the innovation. And again, this is where that manuscript that you're generating will be really helpful to patent counsel, is to help flesh out what that description looks like. You're going to have embodiments of the innovation, in other words, examples. So you might have multiple examples or embodiments that are listed in that. And then at the very end of the application, there are going to be claims. And these are really kind of what's the enforceable portion of the patent. I like to conceptually view it as a fence. What I'm claiming is inside the fence, and that's different from what's outside the fence or the prior art. And the types of claims might be compositions of matter. And, these can be very specific. It's, certain elements and certain ratios, or certain molecules, or, or what have you. It might involve the processes useful for making something. And these can, again, be quite specific. What's the temperature range that you're using, or what's the pressure or reaction conditions that are needed or useful for making that. And those can be protected. You'll often have, what are the applications of a material? So I've got a new biopolymer. What can I use it for? And I might have claims associated with that. And as well as an apparatus that might be used, or if I'm claiming an apparatus, what the descriptions of that apparatus are. Now, basically, the application process involves really a couple of things. We're going to draft and file an application. At Iowa State, we don't have any in-house patent counsel. Certain institutions do. It kind of depends on the institution and their budget, and the types of innovations that they practice or do. So, for example, institutions with a research medical school, you might have an IP counsel on hand that handles just those applications. As a cost savings matter. At Iowa State, ours are pretty diverse, from veterinary medicine innovations to animal science, or engineering, chemistry, material science, across the board. And so, we don't have enough weight in any particular area to justify having our own counsel to file those. So we use outside counsel. And that's what they're going to do. They're going to work on using your manuscript to draft and file an application. At some point in time, and I have a timeline in the next line, there'll be kind of this prosecution phase where the claims will be examined. They might be restricted to, there might be a restriction requirement. And what that means is that from a USPTO perspective, only one invention can be in any given patent. And, we've just talked about different things. Often we're going to file, for example, for a new material, we might have claims related to the material. And so those are an invention. We might include in that same application how to make that, or so there might be process claims, and that would be a separate invention, and maybe use claims. What is this useful for? And that might be a separate invention. And so what will happen is, after that examination is started, or they pick that up, they might say there's multiple inventions here, and we're going to restrict you to one of those different ones. And so that's a restriction requirement. And that's just very common for academic patent applications. The patent examiner might object to claims. Often it's very rare that they don't. So it's I've only been a party to a few applications where they come through without any objections. Often that means that we haven't been aggressive enough if they don't object to it, right? So we haven't tried hard enough to claim more broadly. And so that's what's called an office action. And we respond to those office actions with either kind of an amendment of those claims or modification of those claims. The patent office can reject those claims altogether. They can suggest amendments that they would view as allowable. And then we have allowance in issuance of the patent application. So from a timeline perspective, on the far left, we have start. And for the purposes of this slide, that's when we file a provisional application. And those, the cost range for those are typically, $3,000 to $5,000. But that's just an estimate. It kind of depends on the complexity of what we're claiming. And kind of the shape at which and how much interaction is needed between the inventors and the patent counsel to fully enable this. So I've seen provisional patent applications that have cost as much as $20,000 in my experience. And so while 3 to 5 is more common, it could be dramatically more expensive. And that kind of starts the clock. And then by 12 months, we're going to want to either convert that application to a US application, a utility application, or we might file a PCT application, which kind of, again, gives us another ability to file in foreign countries. But that happens at kind of that 12-month standpoint. The patent application is going to be published unless we request that it's not at 18 months from the very first application. So that's a provisional. It's 18 months after we filed a provisional. If utility is the first thing that's filed, it's 18 months after that. But so generally, from an academic perspective, it's 6 months after the provisional application is filed, or the utility application is filed. And then patent prosecution usually kind of gets picked up about 2 years after the utility application is filed. So really before that, there's very little activity. There might be a restriction requirement early on, probably in the 18 months after filing perspective, or in this case, 30 months after a provisional. But generally, very little is happening at the Patent and Trademark Office until about 2 years after the utility is filed. And then ideally, kind of ideal time frame is about 3 years, 3.5 years after the utility application is filed. We might have a notice of allowance and issuance of that patent. So that's kind of that 3 to 4 years. And our typical expenses, from when we look at this from beginning to issuance of a single patent, is probably about $25,000 to $30,000 if we're talking U.S. only. If we do patent prosecution in multiple in foreign jurisdictions, and again we'll talk about that in a minute, that number can mushroom quite a bit. And then, patents are expire 20 years after the first filing. So 20 years after 20 years after the utility application is filed. And so depending on the length of time it takes for prosecution, there's generally another 10 to 15 or maybe a few more years of useful patent life after that. So I talked briefly about different jurisdictions in that claims are essentially enforceable only in the country in which the patent is issued. So US patents are good for the United States, but they have no teeth in Canada or Mexico or Europe or Asia, whether it's Japan, Korea, China. They're only really enforceable in the country in which they're issued. But there are opportunities to file in foreign jurisdictions, provided that there are no public disclosures. I mentioned maybe in the third or fourth slide that the US allows us to file patent applications from 1 year after there's a public disclosure, but that's true essentially only for the United States. Almost every other country in the world has an absolute bar against filing patent applications after public disclosure. So, if the innovation has the potential for applicability outside the United States, it's important for us to have the disclosure before or the disclosure record to us before it's publicly disclosed outside. The things that we consider, and I'm sure your tech transfer office will do the same, is when we're thinking about foreign applications are really what's the likelihood of finding a licensee. Having that application or an issued patent in a foreign jurisdiction is great, but how are you going to use it? So we want to have a licensee that's either going to take advantage of that or need that protection. What's the ability to enforce those IP rights in those jurisdictions, and what are those costs of filing and enforcement? So, for example, it's very difficult for foreign entities such as universities or even practicing entities to enforce their IP rights in China. And so, what is your ability to do that? And that should have an influence on your decision for investment. And then from an enforcement perspective, just a few minutes here that patents are kind of a negative right. And what I mean by that is they allow the patent owner to exclude others from practicing their patent claims. So you can't practice my patent without permission from me. But that's not to be confused with what's considered freedom to operate. Me having an issued patent does not imply that I don't need access to other people's patents in order to practice the claims of mine. So I may need to have access to, a proprietary material that's owned by somebody else, or the rights are owned by somebody else in order for me to practice my patent. So I need to understand that, or the people that want to commercialize it need to understand that there may be other rights that they need access to. So the way that we grant rights to others is through a license agreement. And then, just some really briefly thing here, a lot of university researchers that I interact with think that there's kind of this automatic right for an educational institution to practice a patent. That is certainly not true. It kind of works out that way often. Most commercial entities will overlook an educational institution utilizing their patents as the universities aren't practicing them for commercial purposes. And it's a kind of a bad look often for companies to sue universities for practicing their patents while they're conducting research for the public good. But it's always a possibility that someone might enforce their patent rights on a university if the university is using them. So just kind of a note to self there. And then patent infringement is generally either settled through litigation or through the threat of litigation. And so that's how we go to market there. So what other things come after disclosure to the tech transfer office? So Some of the things that you can do are explore the commercial opportunities as a researcher. So there are things like Innovation Corps, which was a National Science Foundation program that started in 2011 or so, and has been around for a long time, and it kind of expanded to other federal agencies as well. But some basic opportunities for customer discovery, understanding what the commercial applications are, or how you might tailor your research to be of more value to commercial entities. So that's something that can be explored. Typically technology maturation, which may or may not have been informed by I-Corps, but often is done through internal university funding for tech maturation. At Iowa State, we have a number of programs in which we can find funding for tech maturation, or through partnering, so i.e. licensing. And maybe that's the startup company where they will use or try to utilize federal SBIR or STTR funding to do technology maturation, or sometimes other external funding, depending on their the type of innovation and what market they're in. Licensing to existing small and medium enterprises that, again, might leverage that same federal funding to enhance what they're doing with their own internal development funds. And sometimes, we're able to license to large enterprises, though candidly, that's very rare, unless the technology is particularly mature. Large enterprises seem to have a preference for allowing other companies, i.e. startup companies, to de-risk technologies, to mature them, and then buy those startup companies rather than investing, licensing in and utilizing their own resources to mature the technology and develop products. So while it's sometimes happens, it's fairly rare for large enterprises to license intellectual property out of the universities. I just have a couple of slides left, and then we can open up for questions. What's licensing all about? And fundamentally, from my perspective, patenting and licensing provide a framework for companies to invest in technology maturation and product development. Again, most of the technologies or the innovations that come out of university research are really early stage and require substantial investment to mature, scale up, and develop products with. And if there's not an opportunity for companies to have a protection around those, they're just not going to make that investment. And then, from an ISERF position, and again, your institution may vary on how they approach this. Our primary motivations in negotiating license are, one, protection of the institution. We want to make sure that the commercial activities of our partners don't allow our institutions to be financially at risk. So that's kind of a red line that we won't cross. You're going to have to protect the institution from that. Two, we want to ensure utilization to the degree that we can. We're simply not interested in licensing a patent that someone else is only interested in using for litigation. We used to call them patent trolls. It's the kind way of saying that is non-practicing entities who collect intellectual property, and their goal in doing that is extorting or extracting financial benefit from other companies that are utilizing technology. And so we, in our license agreements, want to ensure that we have kind of tools to ensure that utilization by the licensee is what's happening. And then, thirdly, and probably again in this order, we want to derive some economic benefit from an Iowa State perspective. And ISERF that funds our operations. So ISERF is a privately funded or self-funded entity. We don't take money from Iowa State University. Our operations and our investments are paid for through licensing activities, and so we have that. And by policy, we also work to reinvest in research by sharing proceeds with the institution. So that goes back to the college and Iowa State's Iowa State's example, back to the colleges for them to reinvest in research, and then reward inventors. And really, those three elements are what's codified in BIDOL. Those are aspects that have to happen. So that's why we license, and that's what we're trying to accomplish through that. And so at that point, I'd like to open it up for questions. So.
Great. Thank you, Craig. That was very, very, very good summary. Okay. If you have a question, just raise your hand there via Zoom and I'll be over there. Maybe I can start off while everyone's finishing their lunch or whatever they were doing listening. So I had a question, Craig. So you mentioned trade secret and know-how is something that often occurs as we develop a new technology. And you mentioned it might go through your office. What do you advise at that point? Do you give advice? Is that just something kind of between the inventor and what they're doing?
So that will often come up in license negotiation is how do they, we're licensing the patent and just what it is. It's the claims of that patent and the enforcement of that. And it's often not enough to enable the company to utilize the technology. And so for us at Iowa State University, that's often something where we suggest that the company do a consulting arrangement with the inventor or the inventor groups to help them convey that knowledge that's kind of necessary for the invention to work, but isn't included in the patent. So that's the way we're typically doing that. When you do startup companies, that's kind of inherent, right? Because one of the inventor groups, or maybe all of the inventors, might be involved in a startup, and so they already know how to make it work. But when we're talking about someone who's licensing that's not, part of the inventors, that has to be conveyed somehow, and it's usually through a consulting agreement. So
Great, thank you. Other questions?
I can go if no one else wants to talk. Hi, I'm Jay Wackerly at Central College. So we do not have a tech transfer office. I have been told by our dean, who's basically the chief academic officer here, that that's intentional, that there's nothing, so everything falls on faculty if they want to do it. So I guess I'd start with that. If this is a general talk, do you have advice for institutions that don't have a tech transfer office? Because I imagine most of my colleagues at small schools are in the same situation that I'm in.
Yeah, so presumably that means that the institutional policies are that subject inventions are owned by those employees that invent them, and so
yeah, that is my informal understanding. I wouldn't sign my name to say for sure that that's what it is, but that's my current understanding.
Yeah, and so in some respects, you're going to take the place of the tech transfer office. So you'll have the right to file for patent applications and to do that, but you're going to do it at your own risk rather than at the financial risk of the institution. Where things can play is that if it's a collaborative work with someone like Iowa State and there's an inventor with Iowa State, then
yeah, that was gonna be my follow-up question. So like say Nigel and I do something that's really cool but I definitely contributed to it. What
yes.
would
yeah so in that case, we would want to come to an agreement with you as Iowa State or ISERF as to how we want to approach this protecting and licensing this invention. And we've done it a couple different ways. We've had inventors from other institutions where there might not be a tech transfer office agree to assign it to us and be treated as one of our inventors. And so by ISU policy, right, a third of any proceeds that come from it are paid to the inventors directly, right, as cash. And so we have people that will approach it that way. We've also come to agreements where we do, we call it an interinstitutional agreement or a joint ownership agreement, where we agree they don't want to be treated as one of our inventors, but we'll agree with how we're going to divide up any proceeds. Obviously, most often when we have a private individual who owns, they're not contributing to the costs for protection and licensing. They're not, ponying any money for patent protection. That's still at our risk. But we'll agree on, how we distribute revenue, before our policy hits, right? And so, we would just negotiate based on that. So we've handled it both ways, both as a joint ownership agreement between ISERF and that individual, or where they agree to assign and be treated as one of our inventors from a standpoint of sharing of any royalties.
All right, thanks a lot.
You bet.
Other questions for Craig?
I have a question. Hi, Craig. Thanks.
You bet.
I think one of the things I grapple with the most in this area is the kind of inherent tension between not publicly disclosing ideas and also supporting, graduate student advancement and their need to sort of present at conferences, publish papers. I think that's I guess I'm looking for what your recommendations are for navigating that kind of tension across those two responsibilities, I guess we'll say.
Yeah, now, from my perspective, I don't think there may be more perceived issues there than there, from my perspective, than there really needs to be. What we as a tech transfer office want to know is kind of on the front end, what that is early, so that we can make an evaluation, decide to make an investment, and do that and file for patent protection. But once that's done, we actually want the faculty members or postdocs or graduate students to get out there and socialize the innovation and the research that they're doing. That helps us do our job on finding partners. And so, we're very supportive of our inventors presenting and publishing. we just like to have the opportunity to evaluate and protect it first. And then we can make a decision and do that protection work early to provide the best basis for protecting it and commercializing it. So we're extremely supportive of people publishing.
Great. Thanks, Greg. We have 5 more minutes here if anyone has another question. Well, I'll take advantage of one more opportunity. So, Craig, you mentioned part of your job is finding people to either license or do the next steps on this. Is there something we, as inventors of the technology, can do to help in that? And what advice do you have?
Yeah, well, the first thing to do is to publish, right? So once we have made a decision, made some investment in that, we really would like you guys to publish, to give it talks at conferences and the like. Obviously, a lot of times there are companies in it who scour the research literature or who are present at meetings such as AICHE or ACS or different things like that. Again, kind of in the chemistry mindset of where we might be doing presentations. And so that's really helpful for us is if you're doing that. And if you find companies that express interest, to point them back to us. You might also have a kind of a network of your own that work in a certain area, and you can socialize kind of briefly what you've been doing. And again, if they're interested, point them to us. I think I think it's in everyone's best interest for you to not try to negotiate the license or the deal. But if you can, socialize and generate interest, that really helps us in doing that. And often, kind of the most successful licenses are those where the inventor does know, the company or has connections at the company, because, there's a level of knowledge of what's going on there that's better than what we have. So that's really helpful for us.
Great.
I thought of a follow-up to ask Nigel.
Yeah, go for it.
It's essentially the reverse question, and was something I've been thinking about since Laura sort of invited me to be on this, and was when we're thinking big picture about what industries in Iowa would want. Is there any of this reverse idea where there's companies that come to you or something like, there are these problems we're having, and maybe my chemical engineering colleagues know this better. There's more, but as a chemist, I feel pretty far distant, and I never worked in chemical industry or anything. I feel distant from the chemical industry, but they're utilizing a lot of these things. I teach in my classes, and I do. There's lots of potential connections through the chemistry, but I don't know what the practical. You know what I mean? I don't know what the practical needs are of a common biorefinery in Iowa, or a John Deere manufacturing plant, or a Vermeer plant down the road. You know what I mean? Vermeer might need something down the road that I could help with. I have no idea that they need that help, or that they're looking for some solution that a chemist could solve.
Yeah, so kind of a quick answer to that is yes, that does happen where we'll have partners, potential partners out there who will come to the university and say, this is a problem I have. Do you have anybody who's working in this area that we could talk to, maybe sponsor some work with? And so we try to make those connections. I think that, one of the other things, and I know Nigel has participated in ICOR a number of times, having, some idea of what's doing in the lab, and then having some kind of framework for interacting with companies and kind of discovering what issues they have is another great way to kind of foster that type of relationship. And I won't speak for Nigel, but I think I've seen a number of groups that just the interaction with companies can lead to sponsored work, or to lead to new insight as to what problems are really being experienced within industry. So
it might be more company specific. Like I said, it might be better for me to contact Vermeer or Pellicorp, right? Like, hey, you got, need whatever. Are they looking for solutions to a problem? We have pretty good relationships with both those companies, but by relationships, I mean they just hand us money for stuff, right? It's not reciprocal. So
that's one good relationship. Getting money for stuff is a big positive. Yeah. But I think from an ICOR perspective, it's not tell me what your problems are. It might be related to, well, tell me how you address this. And try to understand, how do they approach different things that you perceive might be a problem, or might be based on what you know of their business. From a chemistry perspective, and then again in that mechanical thing, how do you address corrosion? Is that a big problem? Does that keep you up at night? Is that something that you'd like to see alternative materials for, et cetera? It's not just they're probably not going to bare their souls to you about what.
Yeah, but I mean, obviously, I live in a town full of engineers, as you all do, right? And so they talk. When you get to know them, they kind of talk to you about some things, and it sounds like there's there's lots of problems to be solved, and I'm not saying I have a solution for any of them, but if there's 100 problems, maybe I have an idea to solve one of them, right? You know what I mean?
Yeah, no, absolutely.
Great. Well, we're up on our time, so just want to again thank Craig for his time. Appreciate it, and yeah, and thank you for tuning in for our first Lunch and Learn. So that will
Thanks,
end.
everyone.
Thanks, Craig.
Thank you.